This is probably worse than Roe v. Wade being overturned. You have no goddamn idea. The National Marine Fisheries Service, following regulation passed by Congress, ruled, in the absence of any specific writing on the subject, that observers who were required to be on board herring fishing vessels would be paid $710 or so a day to compensate them for monitoring the catches and releases. Now, the legislation put forward by Congress never actually specified how much these observers get paid or whether they get paid at all. And the reason why that issue was settled was because the Chevron deference established in the 80s allow small regulatory nitpicks like this to be addressed by relevant federal agencies, the administrative state. The Supreme Court just overturned it. It's all on the menu now, boys. Every piece of regulation, all of it, no longer does it get deferred to the administrative state where experts can rule on tiny little nitpicks and you know, weigh on their expertise. Now the courts get to settle everything. We going back to the 1910s, boys. Leaded gasoline is on the menu.
Big decision from the Supreme Court overturning Chevron NRDC. For that, we'll turn to Eamon Javers. Hey, Eamon.
Carl, that's right. This is a sweeping decision by the Supreme Court to overturn what's called the Chevron precedent here. The reason it's significant is because it has enormous implications for the administrative state in the United States of America and all federal agencies and their ability to interpret the law. What the Chevron precedent was a 1984 case from the Supreme Court which held that in absence of other information, courts should give deference to administrative agencies' interpretation of the law. That gave a huge...
It's going to be impossible for anything to get done now. Congress has been gridlocked for decades, and now the administrative state can no longer rule on and make any adjustments to existing regulation or challenges or clarifications brought to it. Bro, this is just one bad day into the next? Yes, that is how that works. Yesterday was yesterday. Asbestos is on the menu, boys. Asbestos is on the menu. Oh, man.
Huge area of wiggle room for federal agencies to interpret what Congress meant when it passed given laws, if there was any gray area in those laws. What the Supreme Court is now saying this morning in a 6-3 decision is that courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. Chevron, they say, is overruled. Again, that is a 6-3 decision. One interesting point here, going back to the Chevron case originally in 1984, the Supreme Court writes, Chevron decided in 1984 by a bare quorum of 6 justices.
Is this the fascist goal to clog up the system? Yes. The Chevron deference was originally celebrated by conservatives because it was ruled in a manner favorable to the Reagan administration. But in the recent decades, it's become a target for the far right because they see it as instrumental in the administrative state, which is something that they want to deconstruct entirely. I mean, you can read the Wikipedia page, man. This is huge. It's probably bigger than Roe v. Wade. Chevron is probably the most frequently cited case in American administrative law, but some scholars suggest the decision had little impact on the Supreme Court jurisprudence and merely clarified the court's existing approach. Not anymore. It's not the existing approach anymore.
Justices triggered a marked departure from the traditional judicial approach of independently examining each statute to determine its meaning. So some skepticism here of whether that case was originally decided correctly. The Supreme Court now saying it was not. Chevron is overturned, and there's going to be enormous questions now, Carl, for administrative agencies across the federal government as to how they move forward with interpreting rules when there is a gray area in the law. A lot of uncertainty now.
This basically like breaks the system. There's literally like this is like a bedrock of the way the government functions now. This is not how it works anymore. You know? Like there's no way around it.
For federal agencies, Carl. Back over to you.
And Eamon, is the idea that they would have to continually check back with Congress, or is it just up to Congress to kind of micro-legislate all of these elements?
Yeah, look, I mean, we're going through this this decision here this morning. And
yeah, the Supreme Court just ruled that it's essentially legal to bribe state officials, or at least in some specific circumstances. I think they also ruled today that it is lawful to punish homeless people for being out on the streets, even when there is no adequate housing for them to stay at otherwise.
See if the Supreme Court is giving any guidance here, but I mean, one option would be that Congress has to go in a detailed way. And
they also ruled on this. Oh yeah, also today, they ruled that we were too mean to the January 6th insurrectionists. That's right, the Supreme Court, unironically, is like, yeah, the beer hall putsch guys were overcharged. The Supreme Court ruled the Justice Department overstepped by bringing obstruction charges against hundreds of people who rioted at the U.S. Capitol on January 6, prompting at least some of these cases to be reopened. Wow, a 6-3 majority. That's crazy. Wow.
And detail all the stuff that regulatory agencies have been doing between 1984 and until today. Another option would be that, the federal agencies would get some deference unless there was a lawsuit challenging that. We'll have to see what the Supreme Court said. There's a lot of fallout here still to come, but Chevron.
Oh, yeah, there is. Let's talk about the Jan 6 ruling.
More breaking news, this time about the January 6th rioters. The Supreme Court has just ruled. Let's get to Shannon Bream. What did they say?
So what they have said is that one of the statutes the Justice Department used to charge hundreds of different January 6 defendants is no good. And that includes President Donald Trump, because he has actually had 2 of these counts against him in the Jack Smith D.C. case against him, that federal criminal case that has been on hold here. So what essentially they say is this statute, which was passed in the wake of Enron, they say it doesn't fit here. He says, given that
Kentucky Brown Jackson voted to let the January 6 riots go, ACB dissented with the libs. Interesting. What strange bedfellows we make.
the subsection
Did
was
I say Kentucky? Sorry, I'm tired.
enacted to address the Enron disaster, not some other far-flung set of dangers like what happened just right over here at the Capitol. It is unlikely that Congress responded with such an unfocused and grossly incommensurate patch in English that essentially means that all of these people who were charged under this particular obstruction statute for January 6th, that is no good. The dissent, this is a very interesting vote made.
Kentucky Jackson sounds cool. Kentucky Jackson sounds like something All Might would scream before punching somebody into space. It's a very American name. Kentucky Jackson. That's like Duncan, Idaho shit.
Because the dissent is actually written by Justice Barrett, and she is joined by Justices Sotomayor and Kagan. She says that Congress did intend for this kind of conduct to be brought, particular obstruction charge. She thinks the majority got it wrong. But what it means is a big headache for the DOJ and good news for hundreds of January 6 defendants charged under this statute, again, including President Trump.
It's a big ruling, too.
Yeah.
I mean, these are big cases. Let's bring back Andy McCarthy, Jonathan Turley. Andy, this is, what does it mean? Big picture for these January 6th
and how many people
defendants.
And how many people was this statute? Did it apply to all these cases?
Well, it
I want the
applied to
details
all of
on
them,
this.
or many of them, Dana, in the sense that it was charged in them. It doesn't mean that everybody who pled guilty, for example, which happened massively in that connection, doesn't mean that all those people have preserved their right to complain about that on appeal. So how many of them it will actually benefit is questionable. But the importance here is that they have found that this is an evidence impairment statute. So in other words, for this kind of obstruction to apply,
More breaking
you
news
actually
this
have to
time.
corrupt the documentary evidence that's being presented in a proceeding. The way the Justice Department tried to...
I don't think the consequences of this in the immediate sense are going to be that significant, but the fact that they took this case and ruled the way they did is an indication that they're trying to show up support. Like, this is a partisan decision. The idea here is, like, if we indicate that there was legal wrongdoing in the charging of the January 6 rioters, that like furthers the case from the far right that they're like innocent little beans who were overcharged, or who did nothing wrong. Yeah, but clearly KBJ thought there was something valid here, and I trust her. Well, you know who I don't trust? Liberals. That's the confidence. Or that's the whole point. It's just meant to, like, challenge the narrative. What about the homeless encampments?
But we do have a ruling. This one is on homeless encampments. So this is a case, City of Grants Pass, Oregon versus Johnson. And what the justices are considering here, whether the enforcement
Yes, she
of
is.
generally applicable laws regulating camping on public properties constitutes cruel and unusual punishment prohibited by the 8th Amendment. So we're just getting word in. This is the first opinion that has come out today. Tom, what more do we know about the significance of this case, one we've also been covering here for the last few months?
Yeah, this is one of those really interesting cases I found. I found it fascinating. I was actually assigned this story to cover this case during the day of the oral arguments. For our viewers at home, just for some quick background, this all originated out of Grants Pass, Oregon. And, you know, a very big point with this story, above all else, homelessness is a very serious concern for some parts, for some Americans across the country.
All right, you're waffling, man. I gave you a chance, News Nation, and you're f***ing it up.
Well, that's right, Christine. So if upheld, things will essentially stay the same. But if overturned, cities could punish people for sleeping outside in public, even when there are no shelter options.
This is the most consequential decision relating to homelessness in my lifetime.
The small city of Grants Pass, Oregon, could shape the way cities in Washington and around the country handle homelessness.
This video is from before the ruling was announced, so they're going to talk about what might happen if they rule against, which they did.
The Supreme Court, siding with Grants Pass, would allow cities to ban camping and fine and jail homeless without providing a shelter space.
Those cities who take that approach, it could result in a mass migration of unhoused people from locations where their existence is prohibited to other locations across the Ninth Circuit where it's not.
Seattle University law professor Sarah Rankin says it could mean more policing approaches and reduce investments in homeless services.
It'll make people less likely to emerge from homelessness.
But some government leaders, like Seattle City Attorney Ann Davison, supported the Supreme Court hearing the case, arguing court decisions have paralyzed communities' ability to address homelessness. Mayor Bruce Harrell's office told us the court's decision doesn't change the city's approach, which leads with offering shelter and services, ensuring people come indoors at the same time as we keep spaces clean and accessible for everyone.
I'm Mayor Kevin Schillingham calling the regular meeting of the Burien City Council.
Meanwhile, this year, the city of Burien has tightened its camping ordinance, adding buffer zones to stop people from sleeping within 500 feet of schools, libraries, and child care centers. These restrictions are not being enforced because the King County Sheriff's Office is waiting for a federal judge to decide its legality.
Cities will be emboldened to do those things, but they will be met with the sort of arrows that lawyers still have in their quiver.
And Rankin says that is
super cool. Insurrection, legal. Homelessness, illegal. Regulations, illegal. We got it, boys. The future is now.
All right, let's get to Ron now. Hey, Ron.
Well, another busy day for the U.S. Supreme Court. One of the opinions they just released focused on what has been a huge issue here in the Metro Phoenix area, homelessness. In a 6-3 ruling, the court decides that cities can, in fact, enforce bans on homeless people sleeping outdoors, on sidewalks, in a place like the Zone, even if there aren't an exact number of beds available for all homeless people within a community. It reverses a ruling by the Ninth Circuit Court in San Francisco. So a group of leaders had argued that ruling made it harder for them to simply allow police and city officials to manage outdoor encampments that were popping up in public spaces across the 9 western states from Washington to California to Arizona.
Because you weren't building shelter. Love the issue of homelessness is just seeing homeless people on your walk to Starbucks. That's always been the problem.
Some homeless advocates worry that allowing cities to tell people they have to move along could criminalize homelessness and make the crisis worse. The case is the most significant to come before the High Court in decades on.
Man.
All right, happening now. We're going back to the Supreme Court where the latest round of opinions are in this morning. It was the case involving homelessness and loitering laws.
Can't wait for Trump to win the election and then replace all the old conservative justices. Maybe they get a 7-2, you know?
Supreme Court is permitting cities to enforce bans on homeless people sleeping outside, even if shelter space is lacking. And this ruling comes as a rising number of people in the United States are without a permanent place to live. There are 4 cases left, folks, including presidential immunity and a January 6 case. But let's dig into this ruling with defense attorney and former federal prosecutor Scott Frederickson, who joins me now. Scott, so this was an interesting case. This had to do with the city of Grants Pass, Oregon, and what they were saying, and what they were saying to the Supreme Court, is that they wanted to enforce what they call an anti-camping law or statute that allows police and other local officials to remove homeless people from certain areas of a city. But there were others who said that this was cruel and unusual punishment as defined by the 8th Amendment of the Constitution. So what did the court say?
Well, I mean, it literally means that if you can't afford housing in a city, that you get exiled from the city. Like, that's literally if you're homeless and no housing is provided to you, like, you're literally being exiled because you'll just be arrested if you stay there.
The court, in a 6-3 decision, said that the city of Grants Pass can enforce their ordinance prohibiting and punishing homeless people for sleeping and camping out in public spaces. This was an important decision, not just for the city of Grants Pass, but for all over the country, for all the cities and communities dealing with the homeless population. The lower court had said that, look, you can't go in and punish a homeless person when they have no place to go. And that violates the 8th Amendment cruel and unusual treatment provision. The Ninth Circuit agreed, said, nope, you can't punish homeless. You can't arrest them, detain them, fine them, criminalize this. The Supreme Court overturned that, said, well, yes, you can do that. Cool. The 8th Amendment does not control our homeless policy. And in this 6-3 decision made very clear that communities now, such as Grants Pass or San Francisco or New York, Alabama or Texas, can address homeless by the problem by removing the people from public spaces.
We need to go back. We need to undo Marbury versus Madison, man. Them just saying public spaces while showing park footage feels dishonest. Public means everywhere that isn't private property. Yeah, they can just do whatever they want now. I mean, imagine all of the criteria any individual city could come up with to determine whether or not a person has a, quote, encampment. Will you sleeping in your car for one night because you got kicked out by your abusive partner, but you don't have another place to stay? Does that count? Because it seems yeah, why wouldn't it? Is that not an encampment? You're on public property, unless you're parked in a private lot or something that you have a spot in. If you're out in the street.
The other interesting thing about this is this ruling was challenged below by both liberals and conservatives, by the governor of California and by the states of Montana and Alabama. They all
Isn't your car your property? Yeah, but it's parked on public property if you're on a road.
Attempted to overturn this with the idea of retaining control to address homelessness in their communities. The Supreme Court agreed.
Yeah, so this is interesting, Scott, because, and I know that the court doesn't deal with what would become now a city or a local problem, right? So the city does have the ability to enforce this anti-camping rule. They can remove homeless people. The Supreme Court says you are not punishing them for the simple act of being homeless, being without a place to stay, without a shelter. But now, of course, what do you do with people that you're removing from various public areas? That's something the court is not addressing. But perhaps was there something mentioned in the dissent?
Well, the dissent was very strong in opposing this and saying, you cannot criminalize a person essentially for the status of being homeless when they have no place to go. So essentially, you're arresting someone for their status of being homeless when they have no place to go, when the city or community has not provided a place for them to go. And so they're saying this does violate the 8th Amendment. These people don't have a choice, and then you're turning them in.
Saying that this isn't fundamentally criminalizing homelessness would be like saying that it's okay for a city to have a rule where the police can arrest you for being black because you can always paint your skin or leave the city. Unironically, that's the level we're at now. In an area where you are homeless and there's not adequate housing for you to stay in, your homelessness is essentially a fundamental characteristic that can't be changed without, at the very least, some change in your circumstances. It's not like it's a choice in that moment if there's not adequate housing.
Into criminals. But the Supreme Court took a different view. They're essentially saying, well, the policy on this, the power and authority should reside with the community to determine this. So
one of the worst parts of this is that this is going to lead to an even further flood of homeless people into the cities that don't have rules like this, which means that homelessness is going to become more of an issue in those areas, which means that more local like liberals or whatever are going to be galvanized against the homeless. You know, you're going to have communities that are like, yeah, we don't criminalize homelessness, and as a consequence they get flooded with the homeless, which means that the situation gets actually bad there until eventually they do criminalize homelessness, and then we all feed them into a wood chipper somewhere in Nevada or whatever.
One shouldn't interpret this opinion.
Should we also be mad at RBG for never stepping down? As always, everything is the fault of the liberals. Everything. Allowing McConnell to hold up Obama's justice appointment, RBG for not stepping down when she should have, putting Hillary forward even though she was like borderline unelectable for how unlikable she was, and shafting Bernie, or like not you know, like being that antagonistic towards left-leaning populism. Like at every stage here, the Democrats have fumbled, and they are the ones responsible for this.
To mean that communities are going to go in and start arresting and putting people in jail necessarily. And that's why both progressive liberals, such as the governor of California, as well as conservative states such as Alabama and Montana, challenge this ruling because they want the authority and the power to deal with the homelessness, which at times may mean coming in, doing sweeps, criminalizing people who stay there in violation of their community regulations. So this will import a big change in the way communities can deal with homelessness.
All right. And Scott, real quick, in just 30 seconds, how does then the Supreme Court, when we think about cruel and unusual, there perhaps will be some Americans who will see this ruling and say, this does sound to my non-legal ears like it's cruel and unusual punishment. What did the majority say?
The majority says essentially, and I think it's encapsulated with the phrase of the opinion, which is says essentially, look, the Eighth Amendment doesn't wrestle the policy and the authority deal with homelessness away from a community. The Eighth Amendment doesn't control policy here. Communities do control.
It absolutely does. This is what I mean. Like the rulings of the conservatives on the court are purely partisan. They're enforcing like a nonsensical interpretation of the law. They're not only doing something harmful, they're doing something that's legally incoherent. You can't criminalize a fundamental attribute of a person. You can't like criminalize being poor. You can't criminalize being homeless. That is what, like I said, like this would be like saying, oh, you can't criminalize being dark-skinned. But this city is okay to have a rule where you arrest dark-skinned people because you could always paint your skin white or they could leave the town. They did, though? Yeah, I know, because the Constitution doesn't mean anything, and neither does the Supreme Court. They're high priests.